Good afternoon, everyone. My name is William Pernik.
And my name is Alana Wilson.
Alana and I are criminal defense attorneys who practice in California. And today we're going to continue our series of discussions on criminal procedure and constitutional law by talking about the Fourth Amendment and specifically searches that happen after a person gets arrested, and especially if they happen to have a cell phone on them. Now, Alana, last time we met for a discussion on criminal procedure, we talked about stops and frisks, we talked about knock and announce, and of course we talked about the automobile exception. And so it occurred to me that very logically, having talked about the automobile exception, we need to talk about searches incident to arrest.
Yes.
So Alana is actually a professor of criminal law and criminal procedure in a law school in Santa Clara County, and she discusses these topics regularly with her students, and I think topics that have to do with stops, arrests, cars, and searches are some of the more popular topics, right?
Yes, absolutely. Really, any exception to the Fourth Amendment is something that I think everybody should be educated on.
Now, the Fourth Amendment prohibits unreasonable searches and seizures and requires that police officers, before they invade somebody's privacy, possess a warrant. As an exception to the warrant requirement, police officers can conduct warrantless searches or intrusions of privacy, but only if it meets a specific exception. And so Alana and law instructors like Alana spend a lot of time discussing each and every exception to the Fourth Amendment, and today we're going to talk about search incident to arrest. So
yes, so under this case called Chimmel, a search incident to a lawful arrest, there are limits to that. You can't just search a person's home just because they were just arrested. In fact, the law is that you have to search a person and anything within their immediate control. So think about it as when a person gets arrested, you have to search. You have the ability to search anything that they can reasonably grab or attain. You know, for instance, if there's a weapon nearby, they're allowed to search the area immediately in their control in case they could grab that weapon. So it's for law enforcement safety that is the limit, but it's not a free-for-all. You can't just go search their bedroom closet because the person was just arrested if the person was arrested in their front yard. They can't reasonably go access that bedroom closet. So there is a limit to what can be searched in a search incident to arrest.
in some ways, it's pretty similar to the stop and frisk, which also is done for officer safety reasons, except here it's not only officer safety, but I believe also destruction of evidence. So the rule is that incident to a person's lawful arrest, a police officer may search the area immediately within their control for either officer safety or to prevent destruction of evidence.
Yes, absolutely.
And here's where we get into a very interesting discussion about cell phones.
Yes, and so the question then becomes, well, if my cell phone is in my immediate control, can the officer go through my cell phone? Can they search my cell phone without my consent? And the law on that was decided in this case called Riley versus California, which was a Supreme Court case in 2014, where the Supreme Court ruled that it would be too invasive. It would be a violation of your Fourth Amendment rights for an officer to go through and search your cell phone because that would violate your privacy on that database. So they do, in fact, need a warrant to search your cell phone, even in a search incident to lawful arrest.
And what I find really interesting about Riley versus California is that, number one, the United States government and the state of California jointly appealed to the United States Supreme Court, and they begged the Supreme Court justices to please allow our officers to continue searching people because it was a massive invasion of people's privacy rights. Police officers love getting their hands on cell phones, as we know, for some very good reasons. Our phones have almost anything that one would want to know about us inside of them. You know, what our geolocation data is, what kind of searches we have been doing, what text messages we have been sending, what photographs we have. And so in Riley, for example, they found a treasure trove of information on a cell phone. I believe Riley was stopped for a traffic violation, right, Alana?
Yes, it was for a traffic violation, and then I believe they found a firearm in his vehicle.
His license was expired,
Yes.
and so what they did is they said, aha, you don't have a valid license, buddy, therefore we're going to tow your car. Impound of the car triggers something called an inventory search, which is another exception to the Fourth Amendment requirement. And so, of course, while searching Riley's car, they find some weapons. Then after they found the weapon, says, oh, great, we're going to arrest you, Mr. Riley. And then once they arrested him, they found a phone. They decided to search the phone incident to arrest. And on that phone now, they found evidence that went above and beyond evidence of driving without a license or even having firearms. They found some pretty damning gang evidence. They found photographs and messages that talked about being crip killers and things of that nature. And that, of course, tied Mr. Riley to much more serious charges, I believe, including a homicide. So police officers really didn't want to give up their ability to search anyone's phone. They really didn't want to have to go through the additional step of justifying to a magistrate or to a judge why probable cause exists to believe that evidence of a crime would be located on that phone, because after all, if you pull a person over for a traffic violation, how are you going to justify searching their phone? What evidence do you expect to see there? Evidence of some other traffic violations?
Exactly. There's probably not going to be much on the phone that would help an officer determine whether or not this person was driving without a valid license or something like that. You're just not going to find that evidence on the phone, so it would be difficult to justify why they would even need a warrant in the first place in that situation.
And what's also very interesting is that Riley had some precedent behind it. There was another case called United States versus Robinson, where an officer was allowed to search a pack of cigarettes, which I believe turned out to have some contraband in it. And so police officers and the attorneys for the United States government, for the state of California, they all argued, well, hey, in Robinson, you allowed the search of a pack of cigarettes. How is it any different when we have another physical object that's almost the same size as a pack of cigarettes, can also hold evidence inside it? But the United States Supreme Court disagreed. And not only did they disagreed unanimously. That means a bitterly divided Supreme Court, split along ideological lines, actually agreed 9-0 that this was wrong because of what cell phones have come to represent in our lives.
Absolutely. I mean, the amount of information you would learn about a person from going through their cell phone compared to opening a pack of cigarettes is probably going to be quite vast. So I certainly agree with the Supreme Court here that it is very invasive to go through somebody's phone. I agree that you should need a warrant to do so. And
some of the comparisons the justices were doing, they compared it to reading through a person's diary, being able to know every location where a person has been, seeing their family photos, even information that dates back many years or decades. And so when they considered the totality of the invasion of privacy that allowing wholesale searches of phones would do, they decided that that was an abhorrent practice and it had to stop, and that's why they ruled the way they ruled. And now, if you get stopped and a police officer wants to see your phone, you can politely decline the invitation and make them do their job and get a warrant. Now, if you guys have been watching our videos, you know that Alana and I and other lawyers at the firm love to conclude every discussion with a helpful list of suggestions. Things you can do, tips and tricks that you can use if you're ever in trouble to stay out of trouble. And so with that, Alana, take us to number 1.
So number 1, search incident to arrest. If an officer is going to search you after a lawful arrest, it does have to be a search within your immediate control. They cannot just freely search your home or your belongings after you've been arrested.
A search incident to arrest is not without limits. The area that can be searched is only area that's under arrestee's immediate control. And the objective of this search is to either protect the officer, so for officer safety purposes, or to prevent destruction of evidence. Anything outside of the arrestee's immediate control or outside of those two objectives would not constitute a lawful search incident to arrest. So if somebody did search you unlawfully, your lawyer can later file a motion, and hopefully all of the evidence that was found can be excluded from your criminal trial.
And a search incident to lawful arrest is an exception to the Fourth Amendment. There are several exceptions to the Fourth Amendment. Another one that may be relevant here is consent. So it's really important that if you are arrested, you not consent to a search of anything that is outside your immediate control.
You don't have to be rude. You do not have to fight the officers. You do not have to be profane. You can very politely decline their invitation for you to consent. You could simply state that, officer, I do not consent to any searches. Thank you very much. You're welcome to obtain a warrant. If the officer does not have probable cause to believe that a further search is going to reveal actual evidence of a crime and what they're searching for is not under your immediate control, is not for officer safety and is not to prevent destruction of evidence, a judge is not going to sign that warrant, and therefore that search will never happen.
And as we talked about earlier, a search of your cell phone, despite being in your immediate control, still would require a warrant given the vast amount of data that is on your cell phone. So if an officer attempts to search your cell phone and argues that it's because it is in your immediate control, that is simply not the case. They still would need a warrant to make that search.
If you care about your privacy, please be sure to protect your electronic devices, such as iPads, smartphones, or laptops, with appropriate encryption or password protection. If your cell phone is password protected, the officer cannot force you to turn over the password. They would have to go through a very expensive process of breaking your phone, which also will require a warrant. If, on the other hand, you allow the officer to look through your phone by providing him a password, the officer may find evidence of the crime and claim that you have consented by providing the password.
Lastly, if you ever find yourself the target of a criminal investigation, it's always a good idea to request a warrant, not give any statement, and of course, request the advice of counsel.
Even if you were burning with desire to say something to the police officers, please don't. If you have something important to contribute to their investigation, it's always safer to do it through your attorney. That's because anything you say can and will be used against you in a court of law. But if your lawyer speaks on your behalf, your lawyer can always explain something or provide some additional evidence without it being held against you down the road. We really hope you enjoyed watching this video. Please like, please subscribe, and until we see you next time, please stay out of trouble.